think, Mr. Stafford, this is your motion?
It's customers, Mr.
Well, but I think you're moving to set aside the sale, so I think let me hear from you first.
Certainly.
And counsel, I'll let you know at the outset, with the volume of the materials as well as the technical nature of the case and the issues, I do want to hear your argument, but I will take the case under advisement. I anticipate and try to give you a reasoned decision once I've had a chance to read through the materials at least once or twice more.
I really appreciate that.
And I also want to say at the outset, I appreciate the fact of letting me go of the extra time and the detail in this. That's greatly appreciated. It's also required of this.
Thank you. What happened is banks developed MERS, and MERS was designed to be a holder for the notes, or holder for the deeds of trust, while the notes were spinning around within the system. And they created what are known as servicing rights. Now, in my declaration in support of the response for motion for summary judgment, I give you the standard countrywide servicing right agreement. It sells the servicing rights out of the original note to Countrywide subsidiary, which is Countrywide Servicing. And if you were to look at, and that's made clear in the recital section of the mortgage loan servicing rights purchase and servicing agreement. It says we're selling you these rights. Okay, so what are those rights? Those rights are defined at page 8 of the agreement. And they include rights to the debt, from the interest, the principal, everything on down the line. So all debt that used to be in that note is now no longer there. It's owned by someone else. Then says our statute, our definition of the deed of trust, our definition of beneficiary is different than all these other cases. It explicitly rejected a lot of other cases, and one I want to bring to this court's attention is its rejection of the Hogarth case, which I think is at page 112, I think. It could be 110. But Hogarth, there the Fourth Circuit said, well, a UCC holder is the equivalent of a deed of trust beneficiary under Virginia law. And our Supreme Court said no. I mean, first of all, they didn't say this, but it's worth noting, the UCC is simply a gap fill. If some other law doesn't apply, it will apply.
The discussion of the countrywide servicing agreement as there's no showing that this is the servicing agreement that governs the loan at issue in this case. The document on its face says that it's an agreement between DB Structured Products, Inc. and Countrywide Home Loans. There's no allegation or evidence that DB Structured Products, Inc. is involved here. Furthermore, this is a case where one entity originated the loan and then sold the servicing rights to Countrywide, not Countrywide originating the loan and servicing the rights to a third party. So the arguments I understand Mr. Staffney is making are once again not applicable here. This document is not related to the fact of issue in this case, which I'm going to discuss.
Your objection is noted. I'm going to overrule the objection. I'll let Mr. Staffney present his argument as he chooses, but I'll take it with that.
Your Honor, I think I deal with that in my declaration bringing this to the court's attention. Then if you were to look at page 24 of this instrument, which is the last part of section 5.1, it reads, the servicer acknowledges that ownership of each mortgage loan, including the note, the mortgage, all other mortgage loan documents, and all rights, benefits, proceeds, and obligations arising therefrom or in connection therewith, except with respect to the ownership of the related servicing rights to collect the money, and all rights, benefits, proceeds, and obligations arising therefrom or in connection therewith is retained by Countrywide, has been vested solely in the seller. So what they're saying is their rights to collect on this note, they expressly have divested from the mortgage or from the security. So what we have here is kind of a double split. We have a split in the beginning when they want to split off, they want to split the deed of trust off into MERS and say they own it. And then when that didn't work, the Supreme Court said no, then they said, well, then we're going to argue that the deed of trust is just going to follow the note. And that might have worked had they not split the note apart. And see, the problem here is when you look at our definition of beneficiary, it is the holder, that's singular, of the instrument or documents evidencing the obligations, plural. So what they're doing is they are trying to take, let's take my house. I enter in an agreement with them. I think I'm dealing with a bank. I think that that bank's going to have my house as security. But that bank is trying to give it to security for at least 3 and perhaps thousands of people when they start securitizing. And I think that's mentioned in a footnote and described pretty well by the judge in Colleen v. Aurora. And so the question before you is not only looking at this definition, but is this definition designed to promote the objectives of the DTA, which are, one, that foreclosure be inexpensive, and the court, of course, in Walker said, no, when you create this kind of a system, it's not an inexpensive system because it invites litigation. In Bain, our Supreme Court said, well, you can't find out who the true stakeholder is. We've got questions whether you violated the second policy of the Deed of Trust Act. And finally, most recently, in Bobon, they've indicated where MERS, and we are dealing with the MERS situation, starts this process, you violate the third policy of the DTA. So we start from the proposition that they haven't shown that there is a beneficiary here. And in order to start the DTA process, they have a beneficiary. Endorse Bain. They endorse Bain as being a placeholder for these deeds of trust. Our Supreme Court didn't endorse Bain. The other thing is they relied on Section 20 of the Deed of Trust. And Section 20 says basically that that the note can be split up into pieces. Now, query how the Deed of Trust is able to put provisions into the note with the definition of beneficiary under our law. Because it says the holder. It doesn't say you can split this note up and you can split the obligations up. It says the holder of the document or instrument evidencing all the obligations. They have a duty, a requisite duty, according to Schroeder, the Excelsior mortgage, under RCW 61-24-03078, to not begin the foreclosure until the beneficiary has been identified. However, you can't even begin one under the first section. Well, it's not actually the first section, but it's RCW 61.24010, Prince 2, without having a beneficiary appoint a successor trustee. So if there is no proof of a beneficiary, then they haven't complied with the requisite act, the requisite provision in 03078, plus they haven't complied with 010, because without a beneficiary, you can't create a successor trustee. So what did they do? Nonetheless, even though they weren't a beneficiary and couldn't prove that they were, they decided they would appoint a trustee. And so the person they decided would claim the title of beneficiary, although it varies often on records, is Ben.
I know the court will take this with a grain of salt, but I just have to object to the caricatures and the silhouettes and the other sort of inflammatory images used in this demonstrative exhibit. I also point out just that the exhibit shows a family holding hands, walking away from a foreclosed home. Mr. Bradford was a single man at the time of foreclosure, did not have a wife or kids living with him. So I would just like to object to this demonstrative and put the court on notice that some of these images and structure is deliberately inflammatory and incorrect.
And let me thank Mr. Lorber for pointing that out.
I'll overrule the objection. It is a demonstrative, and it isn't accurate, but I'll allow counsel to supplement his argument with pictures, doodles, diagrams, or whatever he wants.
Thank you.
Thank you, Your Honor. And I'm not trying to pull one over our head. These things are quite expensive to create. So we create them, and this is one that we would use for other judges, too, in other cases. So what happens here?
Some of us need pictures now.
Well, and actually, the guy in the back here drew it. He's starting a company called Case on a Page, and it's a great idea. So what do we have here? We've got Bank, who is a dubious beneficiary, appointing Recon Trust as its trustee. Now, what do we know about the relationship between them? We know that Recon Trust is a wholly owned subsidiary to BAM. Now, were it not perhaps for the recent decision in Clem, we might be able to accept that. But Clem made clear that what we're talking about for a beneficiary is kind of a substitute judge. And I think the way Judge Chambers framed it was, if you go before a judicial foreclosure, you've got a judge of the Superior Court. If you go before this other way of doing it, you've got a substitute judge. And then they went on to interpret RCW 61.240.010, parent 4, the provision requiring a duty of good faith, to constitutionally require that you have a neutral and unbiased judge. Now, that's pretty much on point here, but it's not as on point as 61.24.010, parent 3, which says that the trustee can own no fiduciary duty to anyone claiming an interest subject to the trust. And of course, BANA does, because it's claiming to be a beneficiary. And so, who better than to determine if BANA is a real beneficiary than somebody BANA completely owns?
You can't make a Chinese wall that big.
That's where we get to the problem of you've got the servicer and you got BANA. In this case, we're not doing law firm, but they're working hand in hand. BANA owes a fiduciary duty of loyalty and confidentiality to Recount Trust owes the duty of confidentiality and loyalty to BANA. Now, why is it important? It's important because when you get to the requisites for the sale, they have to show, they have to be able to prove, they have to have proof as to who is the beneficiary and owns the note. And, I mean, if they don't have that proof, or if they have proof, but such as, let's say they had disagreement, and the duty of confidentiality probably would require them to ignore it. I mean, if I were a lawyer, and I'm following my duty of confidentiality, and I'm representing this trustee, I'm not sure I bring this to the attention of the other side. Because RCW 61.24.0307B says that if you violate the duty of good faith, you cannot rely on the presumption, perhaps an irrebuttable presumption the legislature creates by the remark that all you have to say is that the holder is no. In this case, they didn't even meet that standard. So, neutral trustee, to more or less go along with his claims that he was a beneficiary. Then, and I guess we should take a quick look at, stop by RCW 61.24.020, which prohibits a beneficiary, a trustee of a beneficiary, from being an agent for the beneficiary, which clearly under these circumstances, Recount Trust was. So now let's go to, we've talked about 0.24, and now I'm going to assume statute's constitution. We have to assume that, and you've got to find a way to try to make it so. We assume it's constitutional, then there has to be a record that you can consider. And there is no record in the evidence before you that would meet that burden. And the language of 070 is pretty strong. It says, no non-judicial foreclosure shall be initiated, begun, started, or whatever, until you have this proof. And I submit to you, there wasn't the proof of beneficiary, because they had to have proof the beneficiary was the owner of the house. I just want to take a moment and talk about federal court authority to the contrary with regard to the notion that, which no longer even possibly has the debt, is a beneficiary. Well, our Supreme Court directly rejected that in Hobart, in Bing. There are a lot of interesting questions raised by 070A, like what is the burden of proof? Is it the scintilla? Is it a preponderance of the evidence? And this gets to stuff that I will just mention to you because you're the judge that has to figure it out. And I'm not going to, I've got my own ideas, but if you start by looking at Article 4, Section 6 of our Constitution, it enumerates that this court has original jurisdiction of all cases involving the possession and title of real estate. Now there's cases out there like State v. Posey, which is cited in my brief, that says that the legislature can't trump that enumerated original jurisdiction. But there's also cases out there that says you as a court have an obligation to try to determine a law, or try to construe a law to be constitutional. So let's I don't know how you're going to do it, because it seems to me it's pretty unconstitutional, but let's assume that you do it. And then we have the requirements of 070 that says the trustee shall have proof. Now you've got to interpret that provision so it's constitutional. Now, that would seem to go to this court's appellate jurisdiction, yet it's going to oversee the trustee. It's going to need to look at what the trustee looked at in order to make its decision in an appellate capacity as to whether or not that's reasonable. It means nothing. So it's a sham. It's a sham on RDTA as it was intended to be, which was a three-party system where people could go to the friendly neighborhood banker and if there was a problem, work things out. Well, they specifically took our system and said, we don't care, we've got Fannie Mae's system. So in any event, there's some language that I've got in there, and actually I've got a case in the Ninth Circuit that's brought on the way to the U.S. Supreme Court regarding the federal judiciary's attempt to take over land use law. I mean, if you remember before Bain, all of our law was decided by federal courts. And Bain said, hey, no. You got to look at our language. They said, none of these cases are even looking at our language. So certainly, I would hope that you would look at the language of the law. I know once federal judges are anointed, they probably achieve some direct contact with the Almighty, which allows them.
It's okay, we're elected.
Okay, well, that's good. In any event, let me go on to the sale date. We start out with the notice of
120 days.
And by the
Let
way,
me interrupt just a moment, Council, because
Sure.
we've been going a half hour, so.
I'll stop.
Well, we'll only have our reporter until just before 2. She needs to be upstairs. I'm told there are no other reporters. I'm content to have you continue your argument, but you'll just have to realize that unless there is another reporter who comes available, the balance after 2 will not be reported.
I'm very concerned that Mr. Lorber gets a chance to make his, and then we can continue on, and I'll make it without it.
Okay, then let's
Sure.
hear from you, Mr. Lorber.
But I know that I'm in the position of responding to plaintiff's motion for partial summary judgment regarding why the sale should be set aside. But in arguing against plaintiff's motion, I think that what we're going to do is we're going to show the court the actual evidence here today supports the granting of defendant's motion for summary judgment, which is a full motion for summary judgment for complete dismissal. There are a lot of pleadings before the court today, and I appreciate the court's attention and flexibility in allowing us a special set hearing. I also recognize that a large volume of pleadings does not always bode well for a defendant moving for summary judgment. However, in all the pleadings that the court has before it today, there are several core undisputed facts. And when the court considers these undisputed facts, it's clear that our relief should be granted and the plaintiff's relief should be denied. And when I say undisputed facts, what I mean is A, either the defendant submit actual admissible evidence in support of those facts, or B, the plaintiff does not bring any evidence of his own forward to rebut those facts. Because on a motion for summary judgment, as the court knows, once the defendant makes a prima facie showing, the plaintiff has to come forward with actual evidence in support of his claims. Here are the undisputed facts. Mr. Bradburn took out an approximately $200,000 loan in December 2005, and he signed a note and deed of trust. Here's another undisputed fact. The physical possession of the endorsed in blank note has been in the possession of Bank of America or its direct predecessors in interest since shortly after the loan was originated. And that's in the Heather Dispenza Declaration, with a declaration under penalty of perjury that Banna and its predecessors have held the endorsed in blank note. It's also undisputed that Mr. Bradburn has not made a payment since March of 2009. Now, there may be some argument about whether or not he's in default. I'm not going to argue about whether he's in default. I'm just going to tell the court what the evidence is. When Mr. Bradburn admitted in his deposition, he has not made a payment since March of 2009. It's also undisputed that Mr. Bradburn was served with a notice of sale in May of 2011. Mr. Bradburn, we have a declaration under penalty of perjury that the notice of sale was mailed to Mr. Bradburn and posted on his property. And Mr. Bradburn testified in his deposition that he had no evidence to rebut those prima facie valid declarations of service. It's also undisputed that Mr. Bradburn did not file a motion before the sale took place to restrain the sale. It's undisputed that Mr. Bradburn has since vacated the property. And it's undisputed that there have been no third parties that have come forward trying to collect this debt from Mr. Bradburn. Once the sale took place and the debt was extinguished through the sale, nobody came out of the woodwork and said, "Oh no, Mr. Bradburn, you really owe me the money." That did not happen here. So let's look at the foreclosure that occurred. In December 2005, the note and deed of trust were signed in favor of Homestar. On the note itself, it says payable to Homestar, and therefore, under the definition of holder, under the Washington UCC, Homestar was the holder of the note because it was a note specifically payable to a person, and Homestar was that named person. However, as you see from the note that's in evidence, and that's Exhibit A to the dispensa declaration, Homestar endorsed the note specifically as payable to Countrywide, and then Countrywide subsequently endorsed the note in blank. And so when the note was endorsed specifically payable to Countrywide, Countrywide became the holder under the UCC definition of holder. And then once the note was endorsed in blank, the holder of the note was the person in physical possession. And that is just black letter Washington case law under the UCC 62A3205B. When endorsed in blank, an instrument, as it was here, an instrument becomes payable to the bearer and may be negotiated by transfer possession alone until specifically endorsed. Predecessors maintaining physical possession of that endorsed in blank note since shortly after the loan was originated. Now, on June 8th of 2009, Recon Trust, as agent for the beneficiary, issued the notice of default. We have a declaration under penalty of perjury that says that Recon Trust was acting in its capacity as agent when it issued the notice of default. Now, on June 17, 2009...
Isn't that largely a self-serving kind of statement of opinion by the declarant?
I would agree that it's self-serving, but the fact, I would agree that, yes, Recon Trust wants the declaration to say that, but I think the evidence before the court shows that on its face, Recon Trust had authority to issue the document. Recon Trust signed the document in its capacity as agent, and there's no evidence before the court that suggests that Recon Trust was not acting in its capacity as agent. And as I go on to the waiver section of my argument, Your Honor, even if the court finds that that declaration was not good enough, the fact that Recon Trust may have signed the notice of default, that is not sufficient to unwind the sale. So I'll come to that in a second. Operation assignment of deed of trust, transferring the deed of trust to Bank of America Home Loan Servicing, which was Bank of America's immediate predecessor. Now, if this were at the motion to dismiss stage, or the motion for judgment on the pleading stage, we would probably lose under the decision of Walker and Devine. In those cases, extrapolating on the Bain decision, the Court of Appeals said, look, when you have MERS signing these documents, where MERS never holds the note, that's not valid. That's what those cases said. And those cases, like I said, were decided at the motion to dismiss or motion for judgment on the pleading stages when there was no extra evidence brought in for the court to make a decision. But also in Bain, the Supreme Court said MERS can act as an agent. The Bain opinion specifically states that it should not be construed to limit the power of the beneficiary to act through an agent. And in the declaration of Heather Dispenza, who's declared for making that declaration on behalf of Bank of America, Heather Dispenza testifies under penalty of perjury that MERS was acting at the specific direction of Bank of America. who, as we have established, maintained physical possession of the note and therefore was the holder of the note, if I may, Mr. Stastny. Banda had physical possession of the note blank. It's the holder. Here's Mr. Stastny's board. The beneficiary of the deed of trust is the holder of the note. And so because it maintained physical possession of the note endorsed in blank, it was the holder. Because it was the holder, it was the beneficiary. And as the beneficiary, under Bain, Bank of America had the authority to direct MERS as its agent to sign these documents. So, this right. That's the first conclusion, that without even getting into the waiver arguments, the defendants did this right. The party that had physical possession of the note foreclosed in its own name. That's how the deed of trust is supposed to work. It's true that the lending industry attempted to make it easier for themselves with the MERS system, and the MERS system was designed to reduce costs by reducing the amount of documents that the lenders would need to generate and file. Fine. That's true. The Supreme Court said that, no, you can't do that. You can't use the MERS system. And so what we did is we went through our records, and we have the declarations of the penalty of perjury that, yes, we followed the MERS system when we did this foreclosure. This foreclosure was before Bain, but there's no harm here because we had all the proof that we needed. We had the documents. We had possession. The documents were executed by the right parties. And so just because a deed of trust is sold and MERS is involved in the transaction, that does not mean that the sale should be set aside. That's not what Bain says, and there is no Washington authority that supports the proposition that the mere involvement of MERS is sufficient to set aside the transaction. So on Clem, because it's true, Recon Trust is a wholly owned subsidiary of Bank of America. That's a fact. But the deed of trust, while it says that the same entity cannot be both the trustee and the beneficiary, it specifically allows the agent or the subsidiary of a beneficiary to act as the trustee. Specifically allows the subsidiary to act as the trustee, and that's what's happening here. Now in Clem, in Clem, the court set aside the trustee sale on the basis of bad faith on behalf of the trustee. And what did the trustee do in Clem? First, in Clem, the borrower presented to the trustee, they said, look, I've got this purchase and sale agreement for the sale of the property. You give me a couple more weeks, I can sell the property at a surplus, completely satisfy the debt, and I'll walk away with some money. And also in Clem, there was evidence that the trustee falsified documents. There was actual admissible evidence that the trustee falsified documents in order to hurry up and foreclose. There is nothing like this here. There is no evidence of the sort of misconduct that there was evidence for in Clem. There's just the insinuation of misconduct. There's the allegation of misconduct. And those are insufficient at the summary judgment stage. And then Schrader is completely an opposite. In Schrader, it was an agricultural property. The Deed of Trust Act specifically says you can't do a non-judicial foreclosure sale of agricultural property. Schrader was agricultural property, therefore the sale's no good. We don't have those facts here. There is no evidence to support the sort of evidence that those courts require to set aside the sale. So you're left with just the plain language of 6124.127, which says the borrower is limited to money damages only, no injunctive or declaratory relief. And then you have the Brown Doctrine. And the Brown Doctrine says, if you want to bring an action alleging impropriety in a trustee sale in the non-judicial foreclosure process, you need to file a motion to restrain the sale before the sale takes place. And there's three factors in Brown. First, you need to have actual notice of your right to restrain the sale. If your court is convinced by Mr. Stastny's argument about this quasi-appellate capacity, that is a decision to be made by the Court of Appeals. The court should follow the law as it is in Washington now and reject that argument. And if Mr. Bradmore wants to appeal and the Court of Appeals buys his argument, so be it. But the law in Washington right now is clear, and the court should follow that law. Now, I just want to, and I know that we're nearing 2 o'clock, we're at 2 o'clock, and so I'm just going to wrap up real quick with a discussion of the Zalap case. This is a case where the ultimate right to receive payments under the loan is vested in Fannie Mae. It's a Fannie Mae loan. And Bank of America Bank of America and its predecessors were acting as servicing agents for Fannie Mae. Because they had a deal with Fannie Mae, as testified to in the declarations, they had a deal with Fannie Mae. Look, we're going to deal with the borrower, we're going to collect the loan payments, we're going to handle the foreclosure if necessary, but we're going to remit the payments to you.
Yes, let's get down to the nitty-gritty evidence. I don't recall seeing any evidence about remitting payment back and forth between Fannie Mae and moreover, and I think you said it well, with regard to self-serving declarations. Sure, people can have self-serving declarations, but generally they have to establish an adequate foundation. They got to establish personal knowledge, and they're not entitled to state legal conclusions. And that's all their evidence does. The evidence they have submitted is virtually not evidence at all within the declaratory form. And the evidence that they have submitted attached to the declaration, such, for example, that MERS was acting as an agent for bank. That's not what the document itself says. It says MERS is acting as MERS. It doesn't say it's acting as an agent for anybody. And if you go and look at both notices of trustee sales, they identify MERS as the creditor. So, I mean, even if you look at their evidence, what they want you to buy into is, we are the banks. We can tell you what happened and you should believe us. But you just kind of believe a little cursory investigation, which the court demanded in Walker, suggests that these declarations don't do the job, just because they don't comply with our rules of evidence. I want to talk just a little bit about waiver. My learned colleague, Mr. Lober, I appreciate his thought and his study, but it's hard to read Schroeder, or Schrader as he pronounces it, without coming to the conclusion that every one of the provisions in RCW 61-24-030 is a requisite act. Yes, agricultural land is in one of them. But every single one of them, including the one I'm talking about, number 7, is a requisite. And if it's not met, you don't start the DTA in process. If you don't start the DTA in process, then you don't get to its waiver provisions. Also, if you look at Schroeder closely, it stands for the proposition that the court does not believe that damage actions are waived by the DTA. And I mean, you can look at Walker and Schroeder are really interesting, and they're both going to be up before the Supreme Court. Walker says because RCW 61-24-127 goes ahead and says that if you don't bring these cases until after the sale, they're waived. Therefore, you got to presume that the causes of action existed before. Well, if you look at Schroeder, that's not the case. The case is the legislature just can't willy-nilly go about eliminating causes of action. I mean, they can under the residual jurisdiction, certainly. They've done it in the Workers' Compensation Act. But when you've got enumerated original jurisdiction, and again, that state imposes the latest on that, but there's a good decision out of Division 1 where they talk about how this analysis of subject matter jurisdiction has changed unlawful detainer analysis. It used to be that the courts would say, well, you missed the statutory deadline therefore we no longer have subject matter jurisdiction. He can't say that anymore because the way they look at subject matter jurisdiction as it being conferred upon the court by the Constitution. So, in any event, it's, I had forgotten my thought in the street. But the point about waiver, I would also bring the court's attention to the case of Plain v. Lackey, which is considered the foremost waiver case and directed to footnote 6. Footnote 6 basically indicates that in Cox v. Lemus, the court invoked the provision 030 Grand 5 to hold that there was no waiver when you haven't complied with the requisite provisions of the Act. And it's pretty well briefed in our briefs. Stands for the provision that that federal court believed in West Virginia that MERS was okay, and that therefore Section 20 of that Deed of Trust Act could be used to swirl these things around. Bain says, no, MERS is not okay. And so it raises doubts on the legitimacy of Section 20. Just
doesn't Bain also leave open the possibility that MERS may act as an agent lawfully to proceed in much the same fashion as they have here?
Yes.
This is complicated stuff, as you well know. But I want to take what time I need to become more well-versed with your pleadings. Are there any particular time constraints that you're under on this case?
No.
Well, I would just note that,
before I would be getting a decision to you, so I'll do my best.
No, we're going to need your honor.
Thank you, counsel.
Thank you, Your Honor.
All right.
Do you have any thoughts on today's proceedings?
I think it went well. I think our firm made Mr. Bradford's arguments in a concise and cogent manner, and I think the judge is going to take it under advisement and rule in the favor of the homeowner.
What were the key points, the salient points? I had a question on MERS agency. In this instance, I thought that they tried to make MERS into an agent without any sort of quantum of, evidentiary proof to show that there's a true agency relationship.
Yeah, they had a declaration that they filed after all the events took place that basically said that they had directed MERS to act for them, and that should make them an agent. And the judge is going to look at it.
All right, then. Anyone else?
This one. Oh, please, no. Just quickly. All right. Any questions?
Yeah, what were your thoughts on today's proceedings in a nutshell? Anything key that you're looking at? Or
I think that Scott did a great job of articulating our case, particularly with the definition of beneficiaries defined in the deed of trust. I think the judge has a lot of evidence to look at, and that if he reads the statute closely and listens to our arguments, that he will find in favor of the homeowner on our points.
good. That's a good one.
Homeowner fighters.
Indeed. That's good right there, guys. So I'm still rolling.
Okay.
Any thoughts on today's proceedings, Constable?
I thought the judge was very perceptive. He listened. You can't ask for more than that. It's encouraging to find judges that will take the time to hear the arguments. A lot of times you don't see that happening in the United States, and that's just, to me, awful. Thank you.
I couldn't concur more.
He did listen to you.
I know. I said.
Yeah,
I know.
he did.
I know.
Right.
Bob, yeah, he did. But it was refreshing.
It was.